Yeah, it looks like I'm sure people will still join as we go, but yeah.
I want to welcome everyone this afternoon to have a conversation as a part of our annual Nelson Mandela Social Justice Day. Reminder that USI is an engaged learning community committed to an exceptional education. We exist to provide an educated citizenry that can engage in a civil manner within a community with divergent ideas and cultural differences. We prepare our students to lead and make positive contributions to our state, their communities, and to be lifetime learners in a diverse and global society. An inclusive and diverse community is a part of our core values in the USI strategic plan. We believe in the value of human diversity. We continue and strive to foster respect and care for one another and welcome everyone to be a part of our institution. The annual Nelson Mandela Commemoration is a speaker series that directly addresses social justice issues that affect the local or national community. As USI expands its student population, questions of diversity will come into an even starker relief on campus. And this series aims to address some of those issues. I'd like to introduce today Chris Daley. An Indiana native, Chris Daley joined the ACLU of Indiana as executive director in 2024. He has a bachelor's degree from Indiana University and a law degree from the University of California, Berkeley. Immediately prior to joining the ACLU of Indiana, Chris was the executive director of the Indiana Association of Resources and Child Advocacy. Chris has also worked in Washington, D.C. on improving conditions in jails, prisons, and juvenile and immigration detention facilities nationwide as the deputy executive director at Just Detention International. He's also a co-founder and the first director of the Transgender Law Center, where he advocated and litigated alongside transgender community members and their families throughout California. We've asked Chris to come and speak with us today to talk about two bills in particular, HB 1002, which targets protected political speech, and SB 202, which targets classroom content. Thank you, Chris.
Thanks, Professor Shefveland. So great to be with everybody. Sorry I can't be there in person. Can't wait to get back down to southwestern Indiana. But for now, we'll do this virtually. I'm going to go ahead and share my screen with y'all so we can go through a presentation. This presentation won't take all that long. So the goal really is for me to kind of run through a couple things that happened in this most recent session of the General Assembly, and then open it up for questions and hear your all's thoughts on what's going on. So what we're going to do is go through a couple of these slides, just so you understand who we are. If you're not familiar with the ACLU, we are the American Civil Liberties Union of Indiana. We have counterparts in every state and territory, plus our national partners in New York and Washington, D.C. We're nonprofit and nonpartisan and are proud of both of those things. We work across the spectrum in the state on issues related to reproductive freedom, criminal justice reform, LGBTQ rights, voting rights, and many more issues. Just to give you a sense of what we were involved in this most recent legislative session, we tracked 164 bills, 15 of which we supported, 26 of which we opposed. We testified 15 different times, either in person or in writing, and our supporters from all over the state sent 31,000 messages to legislators opposing some of the most repressive bills that had been introduced. We're going to start with HB 1002. This was a bill that was proposed by the House to raise awareness about anti-Semitism, an issue that I think we all have seen an increase in anti-Semitism throughout Indiana. And it's an important issue that the ACLU works on and wants to continue working on in a way that's constitutionally allowable. The bill was passed by both the House and Senate. The concerns that we had with it, we'll talk about a little bit, but largely were that the way it was written, that it would have infringed on free speech, particularly criticism of the state of Israel. However, once it passed both the House and Senate, some changes were made to it, and Governor Holcomb did veto the bill. It was the only veto that he did this year, and then he issued a proclamation of his own. The reason that he vetoed it, as when the bill was being heard in the Senate, some specific references to the state of Israel were removed from the bill, and he felt that he wanted those to be included, so he did veto the bill and then had a proclamation of his own that included those references. Where HB 1002 would have been included in the Indiana Code was essentially a section that is policy statements, i.e. it is the policy of the state of Indiana that XYZ. It would have applied to all public education, K through 12, and higher education in the state. And for universities, it would have applied to every aspect of campus life. And we think that was one of the really important pieces. There was some confusion even among the supporters of the bill, particularly in the House, thinking it was just a curriculum bill, but it wasn't. The section of code that it would have applied to would have involved conversations on campus, students' use of social media, student groups, and what student groups could or could not say in order to be in compliance with the state policy. And what we were mostly concerned about is critics of Israel, particularly Palestinian Americans and Muslim Americans, would have been at heightened risk for discipline simply because they were participating in protected political speech. To be clear, the bill itself didn't have any enforcement mechanism. It wasn't a bill that included civil penalties or criminal penalties. But what it did do is define just one utterance of anti-Semitism as defined by the bill as discrimination. And we simply just don't see that anywhere else in Indiana code. If you think of the employment context, generally comments have to be either severe or pervasive to rise to the level of workplace discrimination, for instance. This bill was so incredibly broad that even just an utterance that ran afoul of the definition would have been considered discrimination, which then could have led public universities to enforce it in any number of ways. I think one of the things that we've all seen over the last couple of years is particularly higher ed administrators have been put in a very difficult place, both in terms of governing speech and trying to separate speech from unlawful harassment or discrimination. This bill just would have made it even more difficult for those administrators to do their jobs. Many of the universities already have very clear policies about what is harassment or what is hate speech, and all of that is allowable under the Constitution. Generally, right? I haven't seen all of the individual policies, but generally allowable. And so that is the way in which harassment should be dealt with, not through kind of this incredibly broad definition of anti-Semitism. Now, one thing that I'll just share is we spoke with the supporters of the bill who did a great job coming out to hearings in the House and the Senate, meeting with a lot of elected officials. And for them, this connection between being Jewish and critique of the state of Israel was very much tied into anti-Semitism. And they had a very good faith belief that you couldn't separate the two. Now, those of you who followed the bill saw that a number of other folks who were Jewish spoke out in opposition and don't see that same connection. But I think that this is a unique situation in which there are folks within the Jewish community who find these two, Jewish identity and the state of Israel, so closely entwined that it makes it difficult for them to separate out critique of Israel from harassment of folks that are Jewish. Now, at the end of the day, as I said, we did oppose the bill simply because we thought it infringed on protected political speech and don't see the two being entwined in that way. But I will just say that from a cultural perspective, these were folks of acting in good faith who really did believe that the two are very closely entwined. So real quick, just to emphasize where the free speech piece lays in here, individual harassment of a student or a student group is not allowed under the Constitution. As I said, any number of universities already have policies that prohibit that kind of harassment. And that's on any number of protected categories, but certainly on the basis of religion. So if an individual Jewish student is being harassed because they're Jewish, then that certainly is something that the university can and should take action on. If they're feeling that the class that they're in is creating an environment of harassment for them because they're Jewish, that is something that the university should take action on. However, that is separate from this concept of political speech, which you will hear any ACLU affiliated person say oftentimes includes speech that is offensive. If that speech is not directed at an individual person and that person's characteristics, that is protected constitutional political speech. So in any number of ways, myself, I'm a gay man. If someone were to say, as part of a political discussion, that AIDS existed in the way it did because of the irresponsibility of gay men, that's something that I would personally find politically or personally offensive, but that doesn't mean that that's not protected political speech. And so I think that is always what we come back to in these conversations is how do we make sure that an exchange of ideas can happen, but that exchange of ideas doesn't cross over into individual harassment. And I think that that's really where we tried to draw the line on this bill. There were a number of people, again, who supported this bill, who are supporters of the ACLU, and we recognize that it was a disagreement among friends. But at the end of the day, I think that particularly in a public university context, making sure that political speech is protected and that it doesn't get conflated with harassment of an individual student or a student group is an important principle that we uphold. And we were excited to see the changes that were made in the Indiana Senate that made the bill much less focused on critique of Israel. We still oppose the bill because of that section I talked about earlier, where it made one utterance connected too closely to the idea of discrimination. But we did think it was a much better bill after that amendment. And the fact that the governor vetoed it, and this is not on the statute, is a victory at the end of the day. But governor's proclamation is much different than code language that would have enshrined this idea that one utterance was discrimination. So it is one of those situations where we were, pretty deeply involved in the conversations along with community members, and thought that the outcome was one that that we supported in the sense that this did not become part of the law. So SB 202, which I'm sure you all are very familiar with, I'm going to probably go through it and tell you stuff that you already know, was a bill that is now law, that we also opposed simply because we were concerned about the classroom interference. The authors framed the bill as an attempt to promote free inquiry, free expression, and intellectual diversity, and did it in a way that was different than bills that we've seen in other states. So for instance, some of the bills in Florida and in Texas focused on particular kinds of academic pursuit and added prohibitions to them having to do with diversity and offices of DEIB within universities, or made discussions of controversial topics something that could not be happening in universities. This bill, though, is different. It is framed different and much broader. It does not single out any area of study. All areas of studies are subjected to the same criteria, and it does not necessarily on its face outlaw any form of speech. The questions that we'll get into later are what ways can it infringe, and may it already infringe on protected constitutional free speech for folks in the university environment. It's very long and includes a lot of different very specific enforcement mechanisms, the two of which that we were most focused on was this complaint process that it creates for students and other staff members, and the way in which that may be used to expose individual professors to harassment. And then also the ways in which tenure decision and the new 5-year tenure review that is required by the law could also create some problems, both in chilling speech, but then also in the way those reviews are conducted. So real quick, just to, again, you all are probably very well aware of this being in the university environment, but just to go through what the law does require now. And this is every public university in the state is required to do this. The bill was aimed at the Board of Trustees, most of which we all know will delegate this responsibility to others. Most boards of trustees are already, if not all, are already reviewing tenure decisions. So that wasn't a new power, but it did create some requirements for how those reviews had to be done. And then it created the 5-year tenure review. So first, that a professor needs to show that they foster a culture of free inquiry, free expression. They need to introduce students to scholarly work from different political and ideological frameworks that exist within the curricula. And I think this is one of the pieces where things could get complicated. That curricula obviously is either set by the Board of Trustees or the heads of departments. And the question is, do all of the fields of study have this variety of political and ideological frameworks? And then finally, that those professors refrain from sharing their own views and opinions on matters that are unrelated to the areas of study that they are teaching within those instructional hours, so within the classroom. And obviously that can be very broadly interpreted, which creates some concerns. And unlike the bill that we were talking about earlier, unlike HB 1002, SB 202 does have some requirements around how the law needs to be enforced. In particular, the Board of Trustees have to, and as part of that 5-year tenure review process, look at specifically termination, demotion, salary reduction, or other disciplinary action for professors who did not meet that criteria in the previous screen. And those are obviously very, very impactful ways of doing discipline. There is that kind of caveat that the institution create alternatives to these three, but termination, demotion, salary reduction are obviously the highest levels of discipline that a university can take against a professor, and the fact that those were specifically called out is a source of concern. So real quick, the law did carve out activity that professors could be involved in that could not be the subject of tenure review. So expressing dissent or engaging in research or public commentary. That's simply that their own opinions within their field of study or outside of their field of study could not necessarily be factored in. Now, that's it's good that that piece is in there, as we'll talk about the implementation of that and how Board of Trustees actually does that in a neutral way gets incredibly complicated. And then criticizing the institution's leadership, as you all know, that is a pastime of most faculty members. So that was something that was very clearly cannot be excluded from the tenure review. And then finally, engaging in political activity outside of their teaching duties, that is something that is protected. So the bill itself did make some nods towards very clearly protected constitutional speech. The concern for us is that it doesn't go far enough in doing so. The biggest concern of the fact that the law has been passed and is now being, different boards of trustees, and as we talked about earlier, university administrations are now figuring out what their policies should look like around this, that those policies themselves will chill faculty free speech. So if a particular professor feels like they have to include specific, particularly debunked policies, or if they feel like they have to teach their class in a way that isn't true to their own beliefs, they're now required to participate in speech that is not in line with their own kind of pedagogy. That then becomes a chill on their free speech. And it's not simply that they need to do that to avoid those disciplinary actions or to secure tenure, although both of those are obviously important. But we talked earlier about that student complaint process. And if a professor is feeling like that they need to include particular materials simply to avoid having a complaint filed against them, there is every chance that that very act is chilling their free speech. And then as we think about what could happen based on the discipline that we outlined earlier for faculty members as part of the tenure review process, that there are any number of ways there could be selective enforcement. If we think just about the challenges that faculty of color have, all faculty of color, but in particular, when we think of Black women in academia and the ways in which oftentimes their scholarship itself is questioned as whether or not it's valid, whether or not it's rigorous enough, we could easily see the enforcement against those faculty members being much more deleterious to their careers. We could easily see that students in their classes or whoever is doing the tenure review could be more skeptical of the instruction that they're giving simply based on institutional racism and the way it overlaps with institutional sexism. And then obviously faculty who have particular political beliefs or teach in certain disciplines, and this should also say faculty with other demographic characteristics, whether it's being a woman, being LGBTQ, being an immigrant, being from a minority religious belief, any number of those faculty members could find themselves subject to selective enforcement, either by students who have preconceived notion about the rigor of those faculty members' presentations, or just how they perceive their classroom demeanor. And then finally, disproportionate outcomes in tenure reviews, or disciplinary action. We think that this is something where we could easily see protected categories of professors more often subjected to discipline, and it's something that we would be looking at if the law is implemented, that we would be looking at down the road to better understand the ways in which these seemingly neutral terms that we reviewed early on about free expression kind of then combined with this tenure review, all done by human beings who have their own biases going into it, could ultimately have a disproportionate effect again against faculty of color, women, other faculty based on their area of study or their political beliefs. So it's something that we would want to look closely at if the law does go into effect and we do see faculty members being challenged in that way. That really is kind of the overview that I wanted to provide of what we saw in this most recent session. I think we continue to see here in Indiana, but then in other states around the country, what is kind of a coordinated assault on higher education, on kind of free speech for faculty members, but also kind of the ability of students to participate in campus life, to have opinions about controversial political topics, to express themselves in ways that we may not choose to, or we don't want them to, but are protected. I think that it is an increasingly challenging time for, again, everyone in the university environment. And I think that what we always urge folks to do, which I think is why so many of you got into this field, is to kind of turn back to your constitutional principles, to turn back to the principles of education and of liberal education in particular, where we're trying to have folks exposed to different ideas, and really lean into that when we are facing all kinds of challenges, both political and financing, to our universities. We're going to now open it up to questions and comments. I do have a couple things on the screen. If you want to know more about the ACLU of Indiana, please do go to our website. Our contact information is there. We do offer, obviously, legal help. So if you think that you are any government entity in the state is infringing on your constitutional rights, feel free to fill out one of our forms. You will not be surprised that we get a ridiculous number of those intakes every day. We have a legal staff of 3 supported by 3 admin staff members. So it will take us quite a while to get back to you, and we take a very small percentage of the cases that come to us. But if you feel that your rights are being infringed upon by any government entity, please do reach out to us. And finally, if you want to be a member of the ACLU, you can do that through our website as well. With that, I'll go ahead and stop sharing and field any comments or questions you all have. Hopefully this will be as much of an open discussion as possible. So if you have additional things that we all should be thinking about, don't hesitate to share those through, I think, the Q&A. Is that right?
Correct.
Yep.
So I wanted to ask, because a lot of the focus in the initial hearings in the Senate from Senator Daley and with the Education Committee was talking about where this came from. And he was indicating that this was coming from students who felt that their voices were not being heard in the classroom. However, when pressed on that, there wasn't a lot of background information or data. And this is concerning to me, because if this is true, what are we doing in our classrooms that are making people feel that they're not able to express conservative views? Additionally, is this a feeling that students are having? Do we have any data on this? Is this something that's going on across our state?
I certainly don't know anything beyond what you just said in terms of what kind of data exists out there. I think that, and this is going to be so obvious, I'm sure some of you are already doing it. What I would encourage us to do, though, is to open those doors of communication, whether it be conducting your own survey of students at the university to find out, or students within your class. Obviously, there are more ways now than ever before for students to register their displeasure with professors through a number of websites, plus the communication mechanisms that already exist for the university. And I think that your point of not being able to show real data is one of the complications that we see throughout the legislative process, particularly in a state that is a supermajority of one party, that it is much easier when there is no significant opposition from whatever different party it is, right? We see this in California, where it's a supermajority Democratic Party. It is very difficult to push folks for actual data that underlie the bills they're proposing. Without that backdrop, it's hard to know how widespread the problem is, and if there is kind of a problem at its core, or if these are more one-off anecdotes. And again, that's true for this issue, but it's true for so many of the issues that come before legislatures across the country.
Can I ask too? I know that the state of Indiana is this bill is supposed to start July 1st, but the state of Indiana and the legislators failed to define a lot of how these things are supposed to play out. And as you can imagine, we've been having lots of conversations about this. But one of the things that's been really unclear to many of us, and there's people in the chat that I've had these conversations with, so hopefully I'm covering some of their questions as well. But one of the big concerns, and you said, what is in the curricula? So one of the big concerns is what is going to count as intellectual diversity in the classroom. So for example, would somebody who teaches on evolution have to teach about creationism? Would somebody who teaches about human sexuality have to talk about debunked sciences like conversion therapy and those kinds of things? So those are one of the big concerns for us. Another kind of related to that is what our university attorney told us, was that curriculum had to be approved by the chair, but no one is really quite sure what that exactly means and how it's supposed to play out in real time. So I don't know if you had any reaction to any of those questions.
No, and I think it's the challenge with particularly these bills that don't have a ramp up period, and there's not necessarily going to be regulations promulgated by the Department of Ed or other state departments. You're left with the text of the bill. Now, the good news is there is some deference in the bill to the institution, right? So that particular section that you're talking about is the curriculum as approved by the Board of Trustees, or I think it says the individual department, something to that effect. And so what I would really urge folks to do is look at where the lack of specificity, where the institution itself can add specificity that does not require folks to put forward policies that have been debunked. The author of the bill, when it was in front of the House, said multiple times that this is not about junk science. This is not about any particular belief. It is about diversity of thought. And so if you're in a field where there's not a lot of diversity of thought, it's incumbent probably upon that department to make that clear in some kind of document, right? That what we're talking about are political or ideological positions that are defensible, right? And that are meaningful within the course being taught. And if you're in a field where there's not a lot of debate along ideological lines, and is more of when you think of kind of mathematics and so on and forth, there's plenty of debate there, but it's not necessarily along ideological lines. And I'm sure there's some professor of mathematics who's going to correct me. Please do. I know nothing about mathematics. But there are any number of fields in which it is important for the department, individual departments, to take a strong stand and to be working with the Board of Trustees to have some of those safeguards in place. And I think it's incumbent upon individual professors to be involved in those conversations with their department. But what I will say is that right now there's no mechanism for the state to come in and define that, or to look underneath the definitions that a department or the Board of Trustees put forward. So some of this really is the university community coming forward and saying, how do we foster free expression without necessarily having to put forward debunked ideas? Because I obviously that's not good for anybody, and that's not mandated by the law, but there does need to be some action within the university community to make sure that's clear.
There's been a lot of concern about how this is going to be implemented. And one of the questions in the chat is, what is the consequence for a university if it does not comply with SB 202?
Yeah, and it's a great question. I mean, I think the thing to always keep in mind is the legislators vote on this, also vote on the state budget, right? And there are significant dollars tied to all public universities in the state from the state budget. I don't believe, unless I'm incorrect, I do not believe that there is like an enforcement mechanism to in some way decertify a public university. However, the Board of Trustees is largely appointed by the governor, and the expectation is that those folks will carry out the law. So I think that the Board of Trustees will likely be the entity that is enforcing this, hopefully in collaboration with department heads and individual presidents of the university. But unless I'm missing it, and again, somebody in the chat, please chime in, there is no kind of decertification mechanism that exists within the statute.
You know, another big concern is the reporting. And from my understanding, it is now required that the people doing the reporting have to be from within the institution. So it can't be outsiders doing anonymous reporting. But there's a lot of concern about a complaint system that could, as you mentioned, target people of color, faculty of color who already have issues in the classroom, or complaining about a bad grade. Or, outside organizations deputizing students to make complaints against targeted professors. So any reaction to any of these issues?
Yeah, I think that's exactly the challenge. Now, first of all, I think it's important to remember that each university already has mechanisms for students to raise concerns about the professionalism of faculty, to the quality of their instruction. So in some ways, this part is the most confusing piece of the bill, because those mechanisms already exist. So now, first of all, the cost of setting up a whole separate complaint system, then tabulating those complaints that come in. This was a non-budget year. There was no money allocated for any of this. The 5-year tenure review is also going to be expensive. So I think that it is very wise to be concerned about any number of groups, whether it's student groups themselves or organizations that perceive that our institutions of higher education slant too liberal, right? I mean, that's what the large concern is out there, will motivate and organize students to go after particular faculty members. Now, the fact that the reports themselves are not allowed to indicate any individual faculty member, and making sure that the folks who compile that are very diligent in making sure that not only names that aren't used, but then there's not other identifying information in those reports will be, I think, very helpful. But in many ways, this goes back to the original question of where's the data. It's a law that's in effect that then has kind of a data piece to it, and it's confusing why the solution is there before the data is there. But I do think that there will be some efforts to justify this law through this complaint process, and we should, kind of be aware of that and look out for that.
A lot of the concerns that are coming up, especially among the faculty, is this defining cultural and intellectual diversity, as well as the legislation of this. And another question is, will the definition, if this is left then to the universities or the individual departments to create and answer to these topics, how are these going to change from institution? How do we progress?
Yeah, I think that the fact that different institutions are going to interpret this differently. Now, it's at the Board of Trustees level, but even when you think of our university systems that have multiple campuses, what will that look like? I think it is something that is going to be hard to understand whether there's a statewide principle involved in this. And I think that to the degree to which the universities can be collaborating on this and making sure that the kind of intellectual integrity of their universities are protected through creating some of their own definitions. I think that we're going to see we would see a little bit more predictability in how this is going to be enforced from campus to campus. But I think right now there's no requirement that universities do that. I don't really know at a higher ed level, how cooperative different university systems are with each other, and if they could even do it. But again, to the earlier point, the time that's been given for universities to do this is incredibly short. So one thing to think about is that 5-year review of the policies that has to be done to determine whether those policies have been kind of correctly drafted, that maybe this first iteration is kind of a draft and, a working draft, obviously, but thinking about how separate universities can come together as part of that 5-year review and really harmonize what they're doing in a way that does protect free expression on their campus and doesn't have this bill chilling free speech.
Another big issue for us is we are educating educators, future educators. And so the big question is, how is this going to impact them? The other thing I don't think the state really considered when they were doing this is that we have obligations to accrediting bodies that require things like diversity education. And so how do you see this affecting future educators? And also, are there any bills going forward to impact secondary education in the same way?
Good questions. I can't say anything about the latter question, obviously not in this most recent session. We won't really know what's going to come up next year until we get there. Folks might remember, though, in 2021, there was the bill about critical race theory and K through 12 education that was similar in many ways. It was, again, targeted to a very specific area of study, and an area of study that wasn't even happening in our K through 12 schools. It was a buzzword. I mean, again, to the earlier point, it was a buzzword that folks got from particular news outlets that they then ran with a bill. So I think that we are absolutely seeing our K through 12 schools be politicized in the same way. There was a bill, again, much more narrow, that would have required school boards from every school district in the state for the school board to have open hearings on human sexuality curriculum and to approve human sexuality curriculum. So yes, I would say that we have seen this at the K through 12, nothing quite this broad. And frankly, the free speech rights of teachers in K through 12 are understood to be different than in higher education, in public universities and higher education. And so the ability to have a uniform curriculum that teachers need to follow in the K through 12 arena is much different than in public universities. So I would say that, yes, our K through 12 are under this same assault, although we're seeing it in many different ways, and it is much easier for the state to govern curriculum in K through 12. I think that certainly our future educators, but just our future residents are getting very clear messages when it comes to this bill and any number of other bills that have a repressive bent to them that the General Assembly has passed. And I think absolutely the choice of your students to in 5 or 10 years come back and teach in Indiana when they can go to states that don't have these same requirements, that don't have 5-year tenure review, is going to be significant. Obviously, your ability to retain faculty right now, your ability to attract current college professors to fill open positions is going to be affected by this law. But I think as we think about current college students and whether or not they want to build their families and make a future in Indiana, this bill and dozens of others that have gone through in the last decade, I think are going to materially impact who wants to live in this state, whether it's access to reproductive freedom, the right to be LGBTQ in this state, to have the healthcare you need. I think all of that is going to affect the willingness of people to stay in Indiana, to relocate to Indiana, and is going to affect our economy and the quality of our communities in any number of ways going forward.
Oh, I can take the next one too, Kristalyn. Okay, sorry. So, another question specifically about SB 202 is, are we just kind of stuck with having to deal with this? Is there that kind of goes to another question. Is there any work, challenging the laws or any appeals against the law? How do we, we're just trying to figure out how we navigate our future as an institution with such restrictive laws coming down. And the other question kind of related to that as well is, from my understanding, this is only one part of, the beginning of trying to chip away at academic freedom. This is not the end.
So all good questions. Right now, no lawsuit has been filed. Faculty members who believe that their constitutional rights are being chilled are encouraged to look into a navigation, the avenue, of particularly filing suit against the law. You can go to our website if you believe that your free speech rights are currently being chilled by the law having been passed. And then, we certainly look at each individual request for representation individually. Barring a lawsuit or barring something else, this law will go into effect. I think the comments that we talked about earlier about the vagueness of so many pieces of the law means it's hard to predict exactly what the effect will be. I mean, we have serious concerns that any implementation of the law will be constitutional. We have significant concerns that implementation itself will create new constitutional concerns. And so I would say that barring a suit being filed anytime between now and July 1st, folks should expect that this is the law. And then, but that just the fact that it's the law doesn't cut off future lawsuits. So in particular, if faculty members feel like they're being targeted, either through the tenure review process or through that student complaint process, people should be tracking that information, should be talking to each other, particularly folks who are share demographics with you, to see if there is that disproportionate impact that we talked about earlier, and to be considering ways in which lawsuits can be filed. And it certainly doesn't need to wait until disciplinary action has been taken, but certainly once disciplinary action is threatened, all of these become different junctures in junctions in which a suit could be filed based on either chilling speech, pending harm, or actual harm that folks experience based on the implementation of the law.
We're starting to see, nationwide, some pretty polarizing impact related to speakers, related to classroom materials. And additionally, we've got a question about the recent announcement that the Supreme Court will not hear McKesson versus Doe. Do you anticipate Indiana adopting similar legislature to Louisiana, Texas, and Mississippi, making it harder to organize mass protests?
Yeah, so there's a lot there. And then I also realized I didn't answer Professor Lynn's question, although this question tees it up really well, the last part of her question, that absolutely we are going to see more bills like this. I think that anyone who wants to know what's going to happen in Indiana in the next couple of years just needs to look at the last 3 or 4 years of Texas or Florida, that those tend to be the laboratories in which the most repressive bills are being foisted upon the country. And there are any number of individual legislators who will pick up those bills and run with them, again, to the point earlier, whether there is documentation or not. I think that we are in a dangerous moment when it comes to free speech, particularly free speech on issues that are perceived to be controversial, or where one political party thinks they can score points by raising the issue. And I think that we are going to continue to see challenges to any number of ways in which people organize and express their First Amendment rights against all kinds of government action or inaction. And so I would say that we have seen a candidate for Senate this year threaten universities with a letter and with their federal funding based on how they respond to protests, and equating, again, very clearly protected political speech with harassment. I think that this is a piece not only that there is some ideological weight behind within certain sections of the country, but I think there are folks in the country who find some of these issues to be very beneficial to them politically by splitting kind of existing coalitions. And so I think that we have absolutely not seen the end of some of the repression that's out there. I think it's incredibly important that we respond to those attempts to repress free speech in a strategic way, and in a way that recognizes that some of what's being done does speak to members who agree with us, to people who agree with us on a whole variety of things, and that we need to acknowledge the hurt that underlies some of that belief, right? That it is really important that we do recognize that that anti-Semitism, for instance, is alive and well in the US, and that we've seen increased instances of anti-Semitism, and that it's incumbent upon all of us to step up to it. Now, we're not going to all agree on what is anti-Semitism, but we can agree that no student based on their religion deserves to be harassed. Unfortunately, a lot of the response to the increase in anti-Semitism makes things harder for students who are Muslim, or students who are Palestinian American, or students who have strong views on the Middle East. And I think that we are absolutely going to continue to see different ways that federal and state legislators try to stoke some of that disagreement through laws that they pass, and in the process try to curb what has been understood to be free speech for decades in the US.
I think as we go forward, we're probably going to come up with like loads of other questions we're going to have for you. So we may have to have you back sometime in the fall. We'll bring you down to Southern Indiana at some point again.
I would love it.
Yeah, but we really appreciate you taking the time to talk to us about this. And, like I said, there's going to be a lot of things going forward for us to think about and how we implement it. But in the meantime, we thank you so much for taking your time to talk to us, and, virtual hand clapping from everyone. So, and thanks everyone for attending. And, if you have other questions, you can pass them along to us and we can pass them on to Chris.
Sounds great. Take care. Thanks for the invite.
Yeah, thank you so much.